Hope you're doing well. Hope you're safe. Hope you're good. Welcome to Lawyers Infohub. If you're a returning subscriber, I appreciate you. If you're new to this channel, please hit the subscribe button, share this video, click on the notification bell so that whenever I drop a new video, you will be aware of it. We're looking at the principle of Autrefois Acquit, also known as double jeopardy. This principle is a principle that came out from the criminal law practice, criminal law proceedings. It's a defense. It's a defense to a person who has been acquitted or who has been tried for a criminal offense, or for someone who has been pardoned, so it's a defense to the person that he can or she cannot be retried again. So this principle, gained its legitimacy or statutory oxygen from Section 36 sub 9 of the 1999 Constitution as amended. So Section 36 sub 9 is is the fact that no person who shows that he or she has been tried by a competent jurisdiction or a tribunal for a criminal offense and is either convicted or acquitted shall be tried again for that offense, or for a criminal offense that has the same ingredients as that offense that he was tried or convicted upon, save upon the order of a superior court. There is a caveat in this constitutional provision, save for the order of a superior court. Now, sub 10 of Section 36 of the Constitution talks about pardon, where a person has been pardoned, either by the governor or by his presidential pardon. The person has been pardoned. The person is stopped from being retried again. So this is a defense for someone who has gone through trial, or someone who has been pardoned, someone who has been convicted or acquitted. He can't be tried again for the same offense, or for the same for criminal offense having the same ingredients as with the one upon which you were convicted or tried. Now, we're going to look at the case of IGP against Sonoma. It's a 2021 case, 12th Nigerian Weekly Law Report, at 1791 at 517. This principle was discussed. Now, what is the importance of this principle? The principle of double jeopardy, the principle of Autrefois Acquit. The first thing you have to understand is that it reflects the importance of finality in the criminal justice. It reflects the importance of finality. If someone has been charged, someone has been tried and convicted or acquitted, why let the person go through the same thing again? So it reflects the importance of finality in the criminal judicial system, and it protects against inconsistent results. It plays a role in upholding public confidence in the judicial system, in the sense that if this person has been tried, for example, the person has been acquitted, it have that confidence that this person is really innocent. Like, why push this person to go back again when the court has, heard the matter and has declared or has, acquitted this person? So it means this person has no case to answer. So it plays a role in upholding the confidence in the judicial system and respect for judicial proceedings, while at the same time conserving judicial resources. Remember that for every, matter or case that goes through the judicial process, resources, human resource, monetary resources are being spent. Even when people that had accused or accused persons, when they bring them from correctional centers, it takes money to bring them to court, to fill the vehicle that will bring them and all of that. So money is involved, resources involved, time, judicial time. So why retry someone who hasn't tried? So it saves judicial resources. But we must understand that this concept, this principle, is not just a Nigerian principle. Yeah, it's not just a Nigerian principle. It's a universal concept. It is a principle that is in all jurisdictions. It's a principle that is seen, or it's in different constitutions, different countries, different treaties, different yeah, not just treaties, declarations, because it's an international um, principle that is universal. It is prevalent in almost all countries, because it's more like it saves someone from going through the process of trial, going through the process of sentencing again, after the person has been, tried. So it's a defense for someone when someone has been tried, convicted, or acquitted, and there's another issue, and this person is coming back to court. This defense can be raised. Though if it's for another offense, it's a different. But if the same defense has the same ingredients as with the one for which the person was convicted, tried, or acquitted, then this defense can avail the person. But remember, there is a caveat as stated in the constitutional provision, that is section 36 sub 9 and sub 10. 10 talks about pardon, that unless by the order of a superior court. Now, this principle can also be seen in Article 14 sub 7 of the International Covenant on Civil and Political Rights. This principle can also be seen in Article 4 of the 7th Additional Protocol of the European Convention of the Protection of Human Rights and Fundamental Freedom. It's there. You can also see this principle in Article 8 sub 4 of the American Convention on Human Rights. Just like I earlier said, it's an international principle that is prevalent in many of these conventions, the declarations, treaties. So also in Article 50 of the Fundamental Rights of the European Union, you can also see a reflection of this principle, because this is an international principle. Like I said, it saves a lot of judicial time, judicial resources. It shows the importance of finality in the criminal justice system. Like, once this person has been tried, why put the person back to go through this whole hurdle of trial again? So it saves time. It plays a role in upholding confidence in the judicial system, and there's it helps to for respect to be accorded to our judicial proceedings, while at the same time we are saving judicial resources. So friends, double jeopardy, principle of Autrefois Acquit, it's one of those defenses that an accused person can rely upon if the offense for which the person is standing trial, he has been acquitted, he has been tried, has been convicted. He can raise it to say, I have been tried, I have been acquitted on this offense, so it cannot be it cannot be litigated again. And if such a defense is being made, it will be sustained. But note, where there is an order of a superior court for someone to be retried for some reasons, which should be stated, then that is the only caveat with respect to this principle. So friends, I just hope this little talk will help you in your growth, in your career, and in your research. Yeah, so we also mentioned the case of IGP against Sonoma. It's the 2021 case. It's the 12th Nigerian Weekly Law Report, Part 791 at 517. I just hope you've learned something, you've learned the principle, you've learned where it is against its legitimacy within the Nigerian context. That is Section 36, Sub 9 and 10 of the Nigerian Constitution of 1999 as amended. We looked at the importance of the principle. Why is the principle important? Yeah, so we looked at it and I hope you've been able to learn something. If you've not subscribed to this channel, please hit the subscribe button, share the video and like saying. Just try and be the best that you can ever be diligent, and know that the sky is just a stepping stone. To take care of yourself.